What you need is some sugar, right?
Yes, like chocolate.
I'm gonna close the door. Thanks. You got that? Yeah. Oh, thank you. All right, my name's Dax Watson. Anybody ever hear me speak before?
Yeah.
All right, that's it. Only one. You're the lucky one that's gonna know all the answers, then, right?
I'll take food and breakfast.
But now you're leaving. Perfect. No.
You told her to go eat.
I have. I always ask that because when I speak, I tend to tell stories and I talk about real life lawsuits. Why don't you back up? Do you guys know what I do for a living? What do I do for a living? Anyone?
Real estate law.
Real estate law. I'm a broker defense attorney. So who do I defend?
Us.
Yeah, real estate companies, brokers. My home group is one of my clients, one of my largest clients now, because you guys are just growing through. Is everyone here from my home group? Because I know they open this up to the public. Anybody not here from my home group? All right, so we can talk bad about other people? No, we wouldn't do that. No, I'm a real estate broker defense attorney. I've been doing it for 20 years. And so when I come out and speak, my goal is to give you information to stay out of my office. Because if you come to my office, what's happened?
Someone's in trouble.
Yeah, someone's in trouble. Someone's been sued, or you have to go visit the Department of Real Estate. Matter of fact, I don't normally even wear this anymore. But if I'm speaking, I have a tie on because when I leave here, I get to go to the Department of Real Estate. Because I get to go sit in a room with the Attorney General and the Department of Real Estate and hopefully negotiate a resolution to a complaint filed against the real estate agent. Right? That's the kind of stuff I do. So when they have me come out and speak, again, the goal is to keep you out of my office. And you might say, well, that's counterproductive because how do you make money, right? Well, trust me, I'm doing okay. Because real estate agents, what happens to real estate agents? They get sued. Why do they get sued? Is it because they're awful and they do terrible jobs all the time? What's the number one reason why you think real estate agents get sued?
Disclosure.
Well, I don't mean the legal claim. Why do you think you're targets in general?
Because we have deep pockets because we're with companies.
You have deep pockets because you have what?
E&O policy.
Say it louder.
E&O policy.
Yeah, you have malpractice insurance, errors and omissions insurance. Plaintiffs' attorneys like malpractice insurance. There's a reason why you see all those commercials on TV where they talk about, hey, we know how to deal with the insurance companies. We know how to deal with the insurance companies. A lot of times that's car wrecks, but it's the same thing. That's why lawyers get sued. That's why doctors get sued. You get sued sometimes because you do things wrong, or a lot of times maybe you do things wrong, but the reason you're a target is because of that. All right, so that being said, what we're going to do today is we're going to go through an exercise that will allow you to see kind of how you can get sued, and we'll talk about practice pointers so you don't get sued and to keep you out of the office. Now, I don't want to stand up here, and you don't want me to stand up here for 55 minutes and just drone on and on and on, because that's no fun, right?
Right.
And only one person here's ever heard me speak. When you heard me speak before, did we break you up into juries and all that stuff?
We did.
It was fun stuff, huh?
We did.
It's awesome. That's why she comes. She's a groupie. She follows me everywhere. That was supposed to be a
That's
joke.
what is done in your office.
Is that what I said before?
Yeah.
Did I really?
Yes.
I know I use that joke all the time, unfortunately. I'm like Seinfeld. I'm a rerun. But anyways, so you may have heard this one before. I don't know if you've heard this one or not, this particular trial. But if you have, then you can still participate. Just don't tell them the end.
Okay.
I just did a really awesome earnest money dispute trial. Over $150,000 earnest money, and the buyer and the seller were fighting over the earnest money, and then they dragged in the real estate agent saying, well, whoever loses, it's the real estate agent's fault. But I haven't quite figured out how I want to talk about that one because it's kind of complex, but I will eventually work that into one of my classes. The one we're going to talk about today, though, was a real life trial that went to a jury trial probably about a decade ago, but it's still one of my favorite cases for a lot of reasons and has a lot of good practice pointers. So I'm going to give you the fact pattern, pay attention. Then I'm going to break you into juries, and then you're going to decide the case, and then we're going to come back, and you're going to tell me how you decided the case. I'm going to tell you why you're wrong. That was supposed to be a joke too. We're going to, come on. No, then we're going to explore, what happened, why you came up with the decisions you came up with, so forth, and so on. All right, ready? Here is the actual trial facts. A real estate agent specialized in finding vacant land for spec home builders. So the spec home builder would hire him to go find a vacant parcel, and then the spec home builder would buy the parcel, build a spec home, sell it, and everybody would be happy. And it's great for this agent because the agent's getting two deals out of it, right? It's getting the vacant land and then gets the spec home flip. And they had done, this particular builder, a particular builder calls him up because he wants to go do another project, and they had done probably about 10 projects together. And they did a lot of projects together in the early 2000s. And for those of you that were back and doing real estate in the early 2000s, how do you think they did?
Really well.
They did really well. I mean, that was when it was booming. And they were making money hand over fist. So anyway, and they became friends because they did a bunch of deals, and They did different things together socially, and it was a great relationship. Well, this buyer builder picks up the phone, calls this agent one day and says, hey, I'm ready to go again. I need a piece of dirt to build a house, but this is gonna be special because I'm not actually gonna flip this one. Times have been going great for me, my construction company's going great, and I wanna build a dream house for my wife and my family. And I'll use it as a showpiece for clients, but this is the one. Now, this particular builder and this particular agent, they specialized down in the Cave Creek Carefree area. That's where they did most of their work. And he said, you know what, you're in luck. There's a subdivision that the developer went ahead and developed like 60 lots. It's a gated community, but he didn't build, he just developed the lots and sold the lots. He sold out, but a bunch of people that bought lots are doing flips right now, or they're reselling. So we can go out and we can take a look at some of these. You're gonna love it. Great, so go out and there's this one particular lot, and it's right up against the subdivision. This is out in Cave Creek, and it backs up against this huge area of open land and mountains and views, and it's beautiful and all that. And as they're walking the lot, there's a conversation, and these are the type of conversations that I live for. These are the type of conversations that are going to put my kids through the Harvard or the West ASU. No? You don't believe that? Well, I might put them through it. I don't know if it's Harvard or the West. But anyways, it's a conversation. The buyer builder says to the agent as he's walking, he's like, wow, this is beautiful, this is awesome, I love the views. Hey, do you think they can do anything with this vast area of state land behind the subdivision that could impede my views or disrupt my pleasure of this lot? Is that an important question?
Yeah.
Yeah. All right. Now, what happens next is why I love these discussions in terms of what I do for a living. There's an answer, but the answer is when we got to trial had how many different versions?
3 or 4.
No, it said 2 versions. They had the version that the agent said and the version that the buyer said the agent said. The agent said that he said something to the effect of, it's state land. Presumably they could do whatever they want with it. You never know. You should go verify what's going on with that land to make certain there's nothing going on. Or at a minimum, this is a town of Cave Creek parcel. You're going to have to go down to the town of Cave Creek to find out what the building permits or the building layouts is or layout are and so forth. Ask them if they know what's going on. According to the buyer builder, the agent said something to the effect of, well, that's state land, but that particular state land is all reserved for wildlife and so forth. They can never do anything there. 2 completely different versions. All right. Buyer goes ahead and puts in an offer. When the offer is accepted, then comes the vacant land spuds. Anybody do vacant land here? Anybody ever done vacant land here? Really? Have you? Have you heard this story before? Did I do this one when you were in my class before? Really? Well, don't tell anybody the punchline. It's a good one though, isn't it?
Yes, it is.
Okay. That reminds me, I gotta do something awesome here. See, we got an extra piece of paper?
Yeah.
I need an extra piece of paper. And I'm gonna need a pen too. I don't need a pen, I just need an extra
Being
paper.
well prepared.
Okay. So, in comes the vacant land spuds. Now, the vacant land spuds are like regular spuds. They say, hey, I'm gonna disclose this, this, and that. But they also have a very important question and answer on there. In the vacant land spuds, it says, hey, is this lot located in the subdivision? And if the answer is yes, the seller needs to attach something to the actual vacant land spuds. Anybody want to guess what that might be? Say it louder. Public report. You guys know what a public report is? Anybody not know what a public report is? Would you admit it if you didn't know? Okay. It says attached public report. Well, in comes the public report, just so we're all on the same page. It's something that a subdivider or a developer puts together in order to subdivide land. And its basic purpose is to tell the world that we have infrastructure. We've got utilities, we've got water, we're gonna have streets, blah, blah, blah. Well, anyways, the vacant land spuds comes in and it's checked yes, but there's no what attached? Public report. Okay. Nobody does anything with it, nobody cares, whatever. They go ahead and buy the lot. Now I should tell you, the listing agent held himself out as having a certain expertise. The listing agent said he was ABC Development, the name of this development's specialist, because he had done about 6 or 7 flips in there, 6 or 7 lot sales in there. So when he was advertising to the world, he says, hey, I'm a specialist in this particular community. Anybody ever see things like that? Anybody do anything like that? I'm not saying it's right or wrong, I'm just asking. Okay. This will be important in a minute, as you can guess. So, they go ahead and they buy the lot. They build a $2 million house on the lot. They get done. They move in. They've been there for about 2 weeks. Mrs. Buyer Builder is standing on the second story in her master bedroom, looking out the window of this beautiful view that they have now procured. And they actually set up their master bedroom in a way so they could take advantage of the best views. And they had glass windows and doors from ceiling to floor. And she's just, wow, this is it. I've made it. This is great. I love it. But then in the distance, she sees something. Matter of fact, she sees more than one thing. She sees about 6 or 7 of these large yellow vehicles with gigantic black tires. And they're driving towards her. What are these vehicles? Yeah, they're caterpillars, or dump trucks, or earth movers. And they keep driving, they keep driving, they keep driving, they keep driving, and they park right outside of her fence. Okay. I'm going to ask you a question in a second, and I'm going to have you answer in a second. But I don't want you to answer it right now when I ask the question. And I'll tell you why. The question, keep this in your mind, don't blurt it out, is what is the worst thing that can be built behind your $2 million house? Don't answer yet. I'm going to write down, this is why I need this piece of paper. I'm going to write down an answer I get every single time that is not the correct answer, but an answer I find hilarious. I've gotten it every time I've ever spoke about this. Now, we don't have a huge group here, so maybe I won't get it this time. But I'm going to write it down because this is the America's Got Talent portion of the show. If I can figure out how this works. What the heck? Well, maybe not.
You can have my pen.
Yeah, this is only going to take me a second. Don't cheat, don't look. I'm going to hand this to you, though. Gosh. I'm not doing well.
Did you bring my pen?
No, I broke the paper, though. Okay, I'm going to trust this with you.
Okay.
You're like the accounting firm, you can't look at this. Alright, so, what is the worst thing that could be built behind your $2 million house? Go ahead, tell me. What else?
Walmart.
What else?
Something to block your view.
Something to block your view. Well, here's the beautiful thing about that. I only had like 3 or 4 answers, and I got both of what I wanted. First of all, I got the right answer, and I also got the answer that's in that paper. The right answer is, what'd you say? Yeah, waste treatment facility. The wrong answer, but the one I think is funny is, read it.
Walmart.
Get it every time. And the reason I think that's funny is people obviously equate Walmart to a shit factory. Okay, get it every single time. It's awesome. No, see what happened is, right when they're in the middle of closing escrow, the town of Cave Creek acquired from the state of Arizona a parcel of land right outside of the subdivision, right outside of their lot, to build a waste treatment facility. And they called it the Water Ranch. Now, the reason they called it the Water Ranch is because in order to get funding to go do something like this, you have to have public meetings and so forth and so on, and you have to advertise them. So they would advertise them to the community and say, hey, come down to City Hall so we can talk about the Water Ranch. What did people think the Water Ranch was? People thought it was like an amusement park or a kid's park. They didn't realize it was a waste treatment facility. And I always have visions in my head of some kid in an inner tube floating in a big pond of you know what. So anyways, so they acquired it and they were building this waste treatment facility. So the buyer is not very happy. Now let's fast forward, or rewind to the public report. Why was the public report important? Well, the developer knew that there was discussions going on between the town of Cave Creek and the state of Arizona, and that this could happen. And right in the public report was a disclosure that said, hey, just so you know, right outside of our fence line, there could be a waste treatment facility. That was in there. Okay, interesting issue. Now, the listing agent, who was a specialist in the area, said he had no idea that they were going to do this. Okay, the seller, now this is important. Seller said we had no idea we were going to do this. The seller was the original buyer of that lot. The original buyer of the lot gets what when they buy that property?
The public report.
The public report. That's who the public report's created for. Public report is created for the very first buyer of a piece of dirt. And in fact, that very first buyer has to sign a piece of paper that says, I've gotten the public report, I read the public report, I understand the public report. And they did. Of course, what did they say at trial?
Never saw it.
No, they said they saw it, but they said what? I didn't actually read it. Okay. You signed that you said that you read it. You signed that you read it. The law says if you sign something that you said that you read it, but you're saying you didn't read it. And they said they had no idea this was going on either. We didn't live there, we just bought this as an investment, blah, 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 blah. So, the builder is mad. His $2 million house, he now opines, and he had an evaluation expert come in and opine, is only worth $1 million because now we have a waste treatment facility behind us. And in fact, I will tell you that they immediately tried to sell the property, and they hired a new agent to try to sell it because they're now mad at their agent. And that agent would list the property, and then as part of the trial, we had several emails shown as exhibits from their listing agent when they would show the property to another buyer, and the buyer's agent would say, "We love your property, it's awesome, but it smells like shit." I mean, literally would say that. Because once they built the actual facility, because I guess they can immediately try to sell it, but when they were trying to sell it, once they built the facility, the town of Cave Creek had problems with controlling the odor. There's certain things you can do to treat, but they were having all kinds of issues. So it was a disaster. It was an utter disaster. In that case, it went to trial. They were asking for $1 million. They sued the listing agent, they sued the buyer's agent, who was my client, and they sued the seller, saying that you all messed up. So I'm going to break into juries here in a second to decide this case. Before I do, let's explore what we're going to be looking at. First of all, Arizona is what we call a comparative fault state. Anybody ever hear that before? Okay, what that means is when somebody files a lawsuit of this nature, the jury looks at everyone involved and allocates a percentage of fault. And the only thing the jury has to do is they have to get to 100%. Okay? Because obviously that is complete. So they have like a pie, basically. I mean, they don't, but this is what they're going to do. And they look at everyone involved, and they just have to divide up that pie to get to 100%. Now, they can do whatever they want. They can give somebody the full 100%, or they could do a quarter or whatever. But they just say, who's got most culpability? So it's not cut and dry that if the buyer's agent's involved, that he gets all the responsibility. They look at everyone involved. Who's involved? I just gave you the three parties, but who else?
The broker.
No. Brokerage is the
Yeah,
same.
okay.
The buyer. So they look at the buyer, and they look at the three defendants, and they say, who's got fault? Because could the buyer have fault here?
Yes.
I mean, they're sophisticated at a minimum, right? Every contract requires them to do some due diligence. There's a factual dispute between the buyer and the buyer's agent as to that one discussion, right? So the buyer could have fault, but then so can the listing agent, the buyer's agent, and so forth. So when you're sitting down, when I break up here in a second, you have to look at these four parties on that fact pattern and decide who's got the most culpability and assign a fault. Now again, if you're in court, that's total hell to pay. That was a joke.
I turned it off.
I think I
before
just scared you on
started.
that.
Yeah. I was embarrassed.
I will tell you this, I was in court once, I was in trial, and my phone went off. And you did a great job. When my phone went off, my ability to realize how to turn off my phone and whatever intelligence I had went out the window. And I'm sitting there like crazy trying to figure out how to turn it off, panicking. I just ripped the back off and pulled the battery out. That's all I could think of doing at that moment, right? But, all right, so you have to just get to 100%. So let's talk about, so the buyer, we know the buyer's sophisticated, we know the buyer has their own due diligence, right? I will tell you that the jury actually believed that the agent's conversation, they believed the agent. They believed the agent said, you go check it out. So they thought that the buyer should have done some more due diligence. But that doesn't mean that the buyer is completely messed up here, because there were some other issues to think about. Buyer's agent. Whether the buyer's agent did have that conversation or not, is that sufficient? Does the buyer's agent need to do something more? Do they have some duty to help them out with that? Do they have some duty to check that out when they know that that's something that the buyer is interested in, what's going to happen with the state land? More importantly, the spuds came in and there was no public report attached. And the buyer's agent did nothing to go get it. Did the buyer's agent have some obligation there? Okay, so then think about the buyer. And don't forget, buyer's agent owes what kind of duty to the buyer? No, higher than that. Fiduciary duty. Highest duty in law. Does that duty require more than just saying, you go check it out? Does that duty require more than just having him sign a spuds without the public report? And so that's one of the things you have to ask yourself. Listing agent. Listing agent held himself out as a specialist in that community with that subdivision and didn't know about the waste treatment facility. Is that a problem for him? Has he created a higher standard of care by saying, I know more about this area than other people, yet he didn't know a very crucial fact? And he provided a spuds that didn't have what?
Report.
Public report. What obligation did he have to make certain the public report was attached? Now, I will tell you, this case is old enough that it was a lot harder to get public reports than it is today. Right now, I could go get a public report online from the ADRE in about 30 seconds. Back then, you didn't have them access online. You'd have to actually, if the seller didn't physically have it, you would have had to go down to the Department of Real Estate to go get it. All right, then you have the seller. Seller says, I had no idea. But the seller owned the lot, and the seller signed a piece of paper, the public report, saying they read it, and it was in there. All right? So those are your four parties that you have to look at, and you have to analyze each one's roles and figure out where you want to go. And I just need you to get to 100%. You don't have to do dollar figures, but you do have to add up to 100%. And if you don't, I'm going to ridicule you to no end. All right, so we have a natural split here because we got 10 people. So you guys, from you over will be a jury, and from you over will be a jury. Actually, you'll have 6 and you'll have 5. So we're going to take about 10 minutes, decide your case, and I'm going to ask you when we're back, what is your percentages? So write them down. Got it? And then we'll talk about those different roles, those different hats, what happened, and how you stay out of trouble. Okay? Go.
Follow up on that. I don't know what's more, make sure that it's
Especially considering the buyers have knowledge
and
and
you hear them, whatever necessarily
that fault as well. So I don't know if I give one.
So I think it's
40
advisable
is
to
20, 20.
hire level of responsibility.
40 to
Higher
the
level,
destination?
higher level of
20 to the
responsibility. But I also think the seller.
Yeah, the seller, because it was the original buyers.
It was exciting, yeah, you should be some specialist, and you should have got that.
Later is a specialist.
In my opinion.
See, he took the transferable account.
That's just my opinion.
I think you're
So I think the seller, the non-disclosure has the biggest liability. Because he non-disclosed and he signed something saying he read
But we
the
only know
report.
what they're telling us.
Shame on him that he
Two.
didn't use
So I agree that.
So in the 4 parties, I think he has the most
For the seller,
percentage.
so.
The second percentage goes to the listing
Because we
agent,
apparently
who
knew.
took the
There's
listing
a possibility.
from the seller
It's hard to
the
believe
seller
that you
is-
signed it.
and should have had
Yeah.
in his
It's hard to
possession. I
believe
don't.
the
You can
Should
jump
have
in.
had in his possession.
You jump in, they'll tell you what to do.
Yeah, that
Yeah.
would be.
So
really-
I think those 2
Yeah.
parties had the most
Yeah, that would
responsibility.
be
of the
Are you cheating? 'Cause you've heard this fact pattern
The
before.
buying agent for the buyer,
Whose responsibility
called
is it
some
to-
specialist, never ever fired some specialist.
So the
Or
listing
specialist
agent.
still calling it out.
But like you said.
So the listing agent, okay, but the buyer's agent has
Because the
worked with
seller
the buyer
got
for a long time, and the buyer had an
public reports once.
excessively high level of
And it's hard to
intelligence
believe
when
that
it comes
he
to
signed
buying
it
land and
and
building.
especially with
So for
the
him to have no
residential.
responsibility
Maybe we
is
can say
insane.
30%,
That's ridiculous.
30%,
Same
20%.
with his
What do you
agent,
want?
should have had some responsibility.
The buyer,
But I'm not sure that it's up to the buyer's
I
agent.
know,
buyer,
but
So-
he's also
He's
a
also
buyer.
expert.
I
He's
think
expert.
it was,
According to
was
the
his
story, he
due
bought
diligence to
6,
sell
7
buyers.
Yeah.
subdivision before,
Was
so
attached,
I assume he has
and
a
that's
knowledge.
a important
But
piece
To
was
take
it
care
his
of that.
job to?
of the formula.
Yeah, it's always your job to look after yourself. Yeah.
So in that case.
That's the public report for the agent,
30,
Someone 10 or 20%
and
for
seller,
him.
right?
because that's his job, is to be responsible for that
And
buyer.
buyer,
That buyer, and under, if he wasn't already a builder, I would.
Maybe we can add 5 to
not
each
too
and
much
make them 35, 35,
responsibility for him,
15,
but because
15.
he's a builder as a business.
Is that right?
Shame on him.
Yeah,
He's an
35,
expert in
35.
land and what can happen.
That's what we
there,
this one.
so he can't
Both
get
parties
built
have
in
rights.
land. You know, so I would have thought he would get a $2 million house, to go to the city of Cape Creek and ask for the.
No,
No, no,
the other way around.
absolutely,
Yeah.
I have a different opinion.
Listen,
I
do
think they're
listen.
all.
Listen,
So, set it as a
Okay,
listing.
mine is not finished.
Distinct seller, right?
Yeah.
So seller and listing, 35 each,
And
and buyer and his agent, 15 each.
has more of the,
Really suck, huh?
responsibility.
Check out my
Um,
reviews. That's what they could sell
yes.
it. Just don't
Yeah,
believe
but
it.
as a buyer,
How
you
savvy
should
the
tell
buyer
your
is.
seller, your buyer
Bottom line
has to
is the
sign
buyer's
it,
agent did not
Right.
ask for
Right,
the
you should
the
mark it on it
process.
and then send a cure notice.
Mhm.
You should
Yeah.
follow it up.
They're gonna say, hey, you could do this too.
Yes,
I
that
don't
is.
know.
Should advise his client on what the next
Especially on
step
something
would
that
be if the
valuable.
seller did not
You know.
provide that value. So.
It sounds like it didn't even come up, you know, and so I.
Yeah, this is a risk, right?
This is real. And then the
Part of the buyer's advisory tells the buyer of what she signs or she signs. That
Right,
they
we
have
don't
X,
tell
Y,
them that,
Z
that
due diligence
most
to
the buyer's
do
agent is
something
responsible.
back.
we know that.
But it does say.
Property.
And that's why it's.
But I still think it's a crucial piece to the puzzle that wasn't provided, and the agent should have known that.
Either way, the
You know,
boss.
so just to let
Well,
that
they just
slide
slide
by.
by, I don't think he should slide, but I don't think he's the most.
You guys working
To work together, it's much
Yeah,
better.
that's what we-
It's only a little,
It'll be interesting.
it's only a couple of cases that yes.
What do you guys think? I don't know. Because telling the buyer, the client buyer, he's got to have the diligence, but then the agent usually.
By the way, all these three parties are.
Seller and the selling agent, the listing agent.
Yeah, not the beginners.
So they're not being liable.
I don't know.
The developer of the subdivision.
But the seller,
One person that's
the seller is
No,
not.
we're supposed to give them the percentage.
Oh, yeah.
So.
The agent, who has the most.
So who is the most responsible?
Maybe that's why he sold the.
I would say the
It's like
seller.
the client.
Yeah.
Yeah.
Right.
Yeah, but it's,
And your opinion,
I think the buyer's agent
has the most responsibility? Then a lot of
It's my opinion, that's what the deal is. So, that was a great, you are correct.
How much money goes to it?
So I wonder what happened, but this thing, I sold 600 lots.
As advised.
There's, it's replaceable, they're gonna sue them from the perspective of,
But maybe it was just a one month. I mean, everyone's still gonna see it, but maybe one or two that they have.
is such a huge part of that.
Views.
But the first issue is, so.
Yeah. Oh, that's what we're talking about, that's the worst to look at,
Well,
right?
buyer signed off, and they said they
Yeah,
read it,
that's true.
but I think
Because we had that happens in Maricopa,
all that's,
you know, the cow farm sells it.
I put myself in their shoes, because I wouldn't want to go back and with my subject account and say, oh my God, it's not zoning, but did I really, did I do what I was supposed to do?
Finding out whether they
Surely
could
signed and
change
said they
the,
acknowledge, let's,
Move it?
the bigger
to
picture for
move
me.
it somehow or to.
what? I've got
The
a fiduciary
facility.
responsibility.
It wasn't built yet.
After,
It wasn't built yet, it was in the
plans,
release.
we'll bring it out.
Discussions with the
Especially
city.
because the conversation.
They call it the water rent.
The gravity of the
So
situation.
just this.
Yeah, I mean, he was
So
only
it-
hiring.
Can
go.
you sue the city too, because they,
Well,
they mislead?
It is in the subdivision.
Oh, yeah, you're right, yeah, you're right. No, but the thing that they miss, in the public record says, the treatment, or is it the water part?
We're assuming, but what he said, when they sent a notice, they call it the water park. To all the owners of that.
So that they will have
You guys close?
no post.
Do you have your percentage?
Yeah.
You got it? How you guys, you got it?
We're hung.
But maybe we should fold it up and.
Alright, well, just do your best, jot something down real quick.
Agents on both sides.
You got yours.
Yeah, I do.
I think there's more. I had good collaborators.
There you go. They're fighting over there.
Buyer's very savvy, I think the onus falls on the agents more so, you know, I think there's responsibility for everybody.
And the seller.
You don't think the seller has the biggest responsibility of the pot?
I wonder how the four parties are experts and they made that mistake. I wonder.
They're not.
Well, they're not all, you mean the listing agent?
Four parties are experts.
Sellers sign.
Oh,
It's
they're
not
all
their, it's not their first
Yeah.
deal, yeah. it's
Even
not
the
their-
seller?
He just
He did,
means
yeah, because he
seller
developed
sold.
many subdivisions, as you said.
Seller sold.
Sorry, the seller, I'm not sure about the seller. I'm talking about his, the specialist,
The listing agent.
The listing agent.
the buyer's agent, the other one. Those are at least the three experts.
Alright, why don't we just bring it back, that's fine. Come on back. Come on back, come on back. We have 29 minutes of fun. I'll let you guys do three. I'll let you guys do two, I mean, you can break it up and we'll do three juries. So we'll start with you guys since you have a collaboration and this is the Jody Arias. Alright, give me, I don't care who says it, I don't wanna know why yet,
No,
I wanna know the
you did
percentages.
opposite. You did the opposite. Yeah.
Yes, you're right.
Okay, so what do you have for the buyer?
15.
15?
Yeah.
Okay, buyer's agent, I don't wanna know why yet, buyer's agent,
15.
1.5? Okay, seller?
35.
35 and 35.
35.
Okay, alright, what did you have for first? It seems so simple.
Oh, I just put the 15
On the wrong
on
people.
the seller and the listing, but I knew what they meant.
Okay, I got you.
I just wrote the wrong.
So you guys can break it up if you want, it sounds like you're at a disagreement.
Yeah.
So why don't we start with you and then we'll go back to that group. So what do you got?
We really didn't get.
Alright, why don't you figure your percentage out, we'll go back there first.
I have mine, but nobody agreed to this one.
Alright, well let me hear yours and then we'll go with theirs. What's
So
yours?
I think
already
the
did.
seller's the most responsible,
Okay, what do you have?
40.
Okay,
I think the buyer's agent, the buyer, and the listing agent are all at 20.
okay.
How about the listener?
Alright, what do you guys wanna do, the rest of you? Anything, anyone? Just give me something. Doesn't, there's no right or wrong
So we
answer.
felt like
By a
the
penny.
agents really bared the brunt.
Okay, so what would you give them?
So let's say, 30% each
Okay,
for the
Oops.
agents,
sorry. Okay, and then what?
and the remaining portion to the buyer and seller then.
20/20?
Sure.
Sure.
Then-
That's like a jury that just wants to get the hell out of here.
May I say 10-40, my opinion?
I'm sorry?
I would put here 10 to the buyer and,
You wanna do your own?
yes, 10 to the buyer.
Alright,
In-
well
in-
what the
in their
heck?
situation.
Alright, what do you wanna do?
This is not
10
an
to
issue,
the
guys.
buyer
10 to buyer. Okay.
and, probably 40.
If you
let's
do
say-
like 43%, then you're gone. What do you want? What do you, what?
15, let's say 20 to the buyer's agent.
Okay. I feel like a game show, you got 70 left. You got
70
70 left.
Seller and the listing agent split,
35/35?
I would say 40-30.
40/30?
Yes,
Who's got the 40, who's got the 30?
I blame the seller, 40,
Okay.
35-35, let's put it 35-35, because 35-35.
I got a 16-year-old that I have more patience for right now. No, I'm just kidding. I'm kidding. What do you want, 35/35?
35-35.
Okay, that's it, no more juries, I'm done with you. I wanna look at them now, I wanna study these for a second, then we'll talk about it. Alright. I wanna look at the agents. So, in general, pretty close, but I think the listing agent got more than the buyer's agent. So somebody jury number one, why'd you give the listing agent 35%?
Because he said he's the expert in the area.
Specialist.
Okay. Is that an issue? Are you allowed, let me ask you this, are you allowed as a real estate licensee, under whether it's the code of ethics or, that's different, that's a realtor, as a real estate licensee, whether you're looking at the administrative code, the commissioner's rules, or the statutes, are you allowed to hold yourself out as an expert or a specialist? How many people say yes? How many people say no? How many people don't want to vote? You're technically allowed, you can say it. If you are what? If you're an expert or specialist, you absolutely, you can't mislead the public, but if you truly are, if you're farming an area and you've been doing it for 10 years and you want to say I'm the, whatever, rancho, blah, 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 specialist, go ahead, you can. Now, that the company may not allow that. I don't know if my home group has a policy of that or not. Some companies don't allow that. But the question becomes, do you want to do it? Why do you do it? What's the benefit of doing it?
To attract.
Yeah, it's marketing.
Yeah.
It's marketing, right? Come hire me because I know more than the average agent in this area. Yeah, I'm better than the average agent. That's why you do it. Why shouldn't you do it?
Because it's
Liability.
responsibility.
You create a higher standard of care for yourself. You've now told the world, I am better, I know more. And so when something like this happens, when there's a major event that is going to impact a community that you say you're the specialist and you don't know about it, you got an issue?
Yes.
You got a huge issue. Huge issue. So I think that's right. The listing agent does have some problems here. Maybe more than the buyer's agent. However, Remember who's suing? Who's suing? The buyer?
Buyer.
What duty does the listing agent owe to the buyer?
Honesty?
Good and faithful, good, fair and faith,
Consideration.
yeah.
Wow.
I can see those two
Come on.
Ask your information.
No, you're going down the right path. You, on the other hand, missed it completely. What did you say?
I said that,
You said nothing. I heard you.
no, because listing agent works for the
teasing.
seller.
I'm kidding you.
I got fair amount of stealing.
It's a duty to deal fairly, is what it is. R4-281101, B, right? You guys read that every morning when you get up, right? When I say R4-281101, do you guys even know what that is?
No.
Do you know what it's from? No, not the Code of Ethics. Code of Ethics is what? That's a realtor rule. That has to do with your designation. R4-281101 is, I heard it, Commissioner's rules. Okay. B says that you owe a fiduciary duty to your client, a duty to deal fairly to all other parties to the transaction. So it's a lesser duty. Still a duty though, right?
Mm-hmm.
Okay. Fiduciary duty here, duty to deal fairly here. All right. What about the fact that they didn't get the public report? Because if you're a listing agent and you have a SPUDS come in that's incomplete, what's your obligation as a listing agent? I mean, whose document is that? It's a seller's document. But you as an agent at a minimum should do what?
Ask for it.
We should point out to them, look, you didn't answer a question. Or you didn't provide this.
Right.
You know, and if they say, well, I don't have it and I'm not gonna get it, then you have to do what? You just say to the other agent, say, look, I just sent this over, I asked them about it, they're not gonna provide it, you gotta do what you wanna do with it. And then maybe let's even move away from this example. You know, in a situation in which they don't complete it completely, or they don't wanna give one, what's your obligation? Your obligation, if they don't wanna give one, is like, well, they're not gonna give one.
Yeah.
Unless, but that has to be in the contract, right?
Yes.
Because the contract says they're gonna give one. They're gonna specifically say they're not gonna give one. But I do think it is their document, they're the ones that are gonna fill it out. What obligation do you have on either side as an agent with SPUDS?
Well, my understanding is if they refuse to fill it out, then you have to disclose what you know.
Well, you have a separate disclosure obligation anyways, R4-281101. Actually, A is the one that says you have fiduciary duty. B talks about your disclosure obligation, which we're gonna get into in a second. But the main point I'm trying to make here is it's their disclosure document, but as licensees, my belief is the standard of practice is you review it, you make sure it's completed thoroughly, and if it's not, if you're on the listing side, you go back to them and say, why didn't you do this? And if you're on the buyer side, you say, hey, they didn't do this. Right? But it's not your document. But you're kind of like the traffic cop, if you will. You know, you're not getting in the car driving anything, but you are pointing out where people should go. Okay, let's keep going. Buy, yes?
Would a waiver will solve all the issues?
Well, it would have been very helpful in this situation if somebody would have said, we're not providing you the public report because we don't have a copy of it. So go get it if you want it.
Yes,
Yeah,
exactly.
but nobody did anything. And fairness, the buyer didn't ask for it. Buyer is a spec home builder. Buyer had done lots of deals, and on the stand I got him to admit he'd done plenty of deals in which a public report wasn't attached to it. That's why nobody went and got it.
Who would you
But-
represent?
I'm not telling you yet. I will tell you at the end. I will tell you at the end. I will tell you that you guys already gave fault to my person. What the heck? Well, I had one of the two agents.
Right.
Let's talk about the buyer's agent. So somebody gave 30%. This was one of my solos.
Yeah.
Why the buyer's agent 30%?
We felt like he has an obligation to ensure that every sale has been turned over. It is.
I'm glad you're going down that route. So you as a licensee, when you wake up in the morning and you put on your My Home Group tag and you have your license and you're going out in business, does that license carry with it a responsibility to investigate issues on behalf of your client?
Absolutely.
How many people say yes?
Yes.
How many people say no? How many people don't want to vote? Not everyone voted.
No,
Did everyone vote?
I did.
Did you not vote?
I did not.
You did now?
I did not vote.
That's not how this game's played. There's no options here. It's either you vote or you don't vote. If you say no, okay. I mean, I'm sorry. You either say yes or no. No, you don't have a duty to investigate. It's a common misconception that you think as a licensee, I've got a duty to go find everything out that my client wants to know about a property. You do not. You do not have an inherent duty to investigate, unless a couple things occur. One is, you can create a duty to investigate by doing what?
Investigating.
By investigating or saying, I'll look into that. So if they're walking that lot and the agent says, I'll go find out for you, then without question, he has now created a duty to investigate. Okay? The other time you will have a duty to investigate is if there's a certain color flag waving in your face, which is what color?
Red.
Red. So let's just change the fact pattern. They walk the lot, he puts in a contract, and then the agent is back in that subdivision driving down that street to go to another lot with another client, looks over and sees a tractor across the way. Is that a red flag?
Yeah.
Now he's probably got, at minimum, he's got a duty to alert his client, but he might even have a duty to start picking up the phone. Right? But you don't have an inherent duty to investigate. Now, why do you? Why was that everyone's instant reaction? Why do you feel that way?
Because of fiduciary.
Well,
Due
it's
diligence.
more so because you want to be helpful to your clients.
No, but isn't it part of the due diligence?
But that's their
To
due
a certain
diligence.
extent.
The question is whether or not you have an obligation to go investigate things on their behalf, and the answer is no. You can create one, like I just said, and you may want to do certain things for them to be helpful, but you do not, in law, have a duty to investigate. Okay? And you have to walk that tightrope of being helpful, because if you just throw everything back on their plate, they're going to be like, what? Like, what the hell do I need you for? Right? But the more you say, I'm going to do, or the more issues they have that you're exploring for them, the more liability you're putting on yourself. Because once you start investigating, if you don't do a good job, guess what?
You're in trouble.
You're sunk. Okay? So he didn't really have a duty to investigate. Now, did he fall down here? Why did he fall down here? What did he do wrong here?
Didn't get the public report.
He didn't get the public report. What else did he not do right here?
I think he didn't recommend the next step for the buyer.
Didn't
of
advise
the
public.
resident, like advise the buyer on what.
Okay, that could help.
What his
That for
options
sure. It's like,
were
you know,
at
the public report didn't come in. He kind of directed him. What's the number one thing he could have done here, though, to stay out of my office? What's the number one thing that he could have, matter of fact, this is the number one teaching point of today. What's the number one thing he could have done so he doesn't have to come visit Dax?
Send a follow-up email for the buyer to do due diligence.
Say that again?
Send a follow-up email for the buyer to do the due diligence.
Boom. I will tell you that 8 out of 10 lawsuits that are filed in Arizona against real estate licensees would be avoided, or I could defeat instantly, if an agent would take 30 seconds to paper their file. If he would have put in an email or a text right after they were done walking that property, you like the property, you're putting an offer in, this is a reminder that you were interested in what can happen to that state land, and you're going to investigate that, game over. It's done. But he didn't. And because he didn't, now what do I have? I've got a he said situation. And he said situations get decided by who?
You.
Juries, not me. By juries and courts. So because he didn't paper his file, he ran into trouble. Now, he didn't have to paper that conversation, right? Did he have to paper that conversation? Is there anything in law that would have required him to paper that conversation? The answer is no. But best practices are what? Cover your ass. CYA. I can't impress upon you more than that. That is the number one way to stay out of real estate jail, is to paper your file. Why didn't he paper his file?
Because they were money.
Because they were friends, and they'd done a lot of transactions. And he didn't think in a million years that there was a miscommunication. And I bet you, if you sit back and think about the transactions you've been in, you've had plenty of conversations that you should have papered, that you didn't, that didn't come back to bite you in the butt, but could have. Let me tell you one of my favorite failing to paper transaction stories. Real estate agents driving in a car with their client. Her client's driving because he had to bring his kid with him to do showing. His kid's in a car seat in the back. As they're driving through this one particular neighborhood, there's basketball hoops in the front yard of several homes. He said, well, you know, I'm glad that there's basketball hoops in the front yard because I want to put a basketball hoop in whatever house that we end up buying. Because even though little Johnny's only 3 years old, and I'm only, I don't remember how tall he was, I'm not super tall and I don't look very athletic, I've seen little Johnny in the family room on our Nerf hoop, and he looks like he's got a really good hand-eye coordination, he looks like he's going to have some real good athletic ability, and I think if I can put a basketball hoop in the front yard, that he can start playing basketball and I can get him coaching and someday he can play in the NBA and make millions of dollars. I'm not making this up, this is a true conversation. And at that point in time, here's the version of the response. According to the agent, she said, well, there's basketball hoops everywhere, but you should check what? The CCNRs and the HOA to make sure that you can put a basketball hoop in. According to him, she only said, there's basketball hoops everywhere. Of course you can put one in. He goes, he buys a house, he goes to put in a basketball hoop, he gets a letter from the property management company saying, you cannot put a hoop there because the ones that are there are all grandfathered in, you gotta take it down. This is one of my favorite stories, because he turns around and he sues the real estate agent. Guess what he was seeking for damages?
NBA salary.
Yep, lost earnings
Oh my God.
for little Johnny's future NBA career. Okay? Stupid lawsuit, stupid damages, but it's a good teaching point. The real estate agent's having a conversation in a million years she doesn't think it's that big a deal, so she didn't paper it. But what if she would have written an email back saying, hey, basketball hoops are important to you, make sure you check the CCNRs. Is she in my office? No. Great agent. I'll bet you everyone in this room knows who that agent is because she's a very high producer. She didn't make some colossal mistake. She just didn't occur to her because it was just a normal conversation. Whenever your clients say something to you, this is important to me, and it requires some kind of due diligence, those are the mother of all conversations that you want to paper. And I guarantee you, if not today, 6 months from now, a year from now, you're going to be sitting having one of those conversations and you're going to think back to this day, it's like, oh, this is what Dax is talking about. Yes?
Still, a verbal exchange, conversation in the car.
Yeah.
How can she prove, even if she mentioned the CCNRs, how can she prove that she mentioned the CCNRs?
She can't, that's what I'm talking about.
The buyer signs the buyer's advisory, 11,
Buyer's
12, 15
advisory.
pages where they are advised to
Okay.
look everywhere.
If the buyer's advisory was a get out of jail free card, would Dax Watson be standing in front of you guys right now?
Nope.
Absolutely not. The contract also says that the buyers and sellers will release and hold harmless the agents, right?
Yes.
If that provision worked, would Dax Watson be standing here right now? The answer is no, I wouldn't have a job. Those things are helpful for what? They're helpful for me to allocate fault. They're helpful for me to say, hey, you signed a buyer's advisory that said go do A, B, C, and D, including getting the public report. Don't think I didn't hammer this guy at trial on that. But that doesn't mean you don't have to do your job. So if a juries will look, when there's an oral dispute, what do juries do? They assess the credibility of the two parties. And they decide who's telling the truth.
Yes.
And if they think that agent's lying, I don't care if there's a buyer advisory at all. Agent loses. That's why you have to cover your trail. That's why you have to paper your trail. All right. Let me switch to facts real quick because this is one other big point I want to get into, and then I'm going to tell you what happened in this trial. Let's say the real estate agent, the buyer's agent, had never done a vacant land deal and went out there and did this deal with this guy and had all these problems. Could that agent have another issue aside from just this disclosure stuff? What is that?
You have to work in your area.
Lack of experience.
Right, Offer Dash 2011-01H. Offer Dash 2011-01H, I usually bring that flyer, I should have brought it with me, or at least that code provision. Says that you have to stay within your scope of expertise as a licensee. There's actually a couple exceptions to that. Anybody know what those exceptions are?
You can call this.
You can what?
You can call this one.
Yeah, you can affiliate up with somebody that does have that expertise, or you can do what? Anybody know? This is my favorite.
Disclose.
Yeah, you can disclose in writing. I don't know what the hell I'm doing. Please hire me. Right. One of the other ways we get in trouble all the time is we get outside of our scope of expertise. Now, some of it's easy, right? If you've never done a vacant land deal and you've only done residential houses, are you probably outside of your scope of expertise on the first vacant land deal? Maybe the first half dozen, right? Because they're just different transactions. If you're a residential agent and you go try to do a commercial deal and you've never done one, are you outside your scope of expertise? Yeah, those are easy. I always ask people this. Very first deal you ever did you tell the client that you didn't know what you're doing and put it in writing? Some of you might have actually got some assistance, but some people don't. Technically, you're probably outside your scope of expertise on your first one, right? If you lived through the short sales, I would ask people, the very first short sale you ever did you fill it up with somebody? Or did you disclose it in writing, you know what you're doing? Inevitably, a lot of people didn't, right? But a short sale, the first time you ever did, we didn't even know what a short sale was. I mean, I practice law. Did I make you yawn? I will call you out on that. I always do that.
It's just after lunch.
I know, I'm just teasing. I yawn in classes too, but I always call people out when they yawn in mine. I'm thinking somebody's gonna get me someday. But short sales, that used to be an area. But here's the number one area, the most common area where people fall short on this. Anybody wanna guess what it is? Were you outside your scope of expertise? Geographic. Okay. That is the most common one that we don't think about. You're licensed to practice real estate in all four corners of the state. But are you within your expertise to practice real estate in all four corners of this state? I had a lawsuit a few years ago where a real estate licensee went up to Anthem to do a deal. It was an East Valley agent. And there was a particular community in Anthem in which the builder had some issues with plumbing. And so the builder got sued in a class action lawsuit, and part of the settlement was, well, if a house ever has any issues with the plumbing, we will replace all the plumbing, all the pipes. That was a settlement. Well, a person goes in and buys the property, they are in the house for a while, they have issues with the plumbing, and they pay a fortune to have it all redone. And their neighbor says, why'd you do that? The builder would have done it. And now they're mad. And they sue the agent because the agent took them out there. Well, every agent in Anthem knew about this, but this agent didn't know. And the listing agent should have disclosed it too, don't get me wrong. But the point is, this agent had no clue, didn't know that that was a common issue in that area in Anthem. Further you get away from your geographic base, the more likely you're going to run into these kind of issues. Luke Air Force Base, zoning overlay. Anybody hear about it? Know about that? What do you want to share what you know, or did I just put you on the spot?
Well, I just know that because of the noise, it has to be disclosed.
Well, there's a zoning overlay that restricts what can be built. And one of the issues was Maricopa County was issuing building permits within the zoning overlay that they shouldn't have issued. And so what ended up happening is people built houses that they shouldn't have. Well, then there was certain cul-de-sacs where there was houses built, but there was vacant lots. Well, then the state of Arizona sued Maricopa County, said stop issuing the building permits. And they said, okay, we won't. Well, so all these vacant lots now, you can't build a house on. But agents are going out there and selling these vacant lots, and people go to go get a building permit, and they say you can't build here. Right? That's an area that people that live out there know about that. Okay? Geographic. That's the other big way. Paper in your file is an issue, geographics an issue. Okay, or state scope of expertise. All right, you want me to tell you how this ended? Anybody have any questions?
I've got a question for you.
Yeah.
So in reference to for the buyer's agent, if the public report was not there, did that not obligate him to work harder to obtain that?
Well, that's an interesting question. I mean, it gets back to what I was saying earlier. If you have a SPUDS that comes in that's not completely answered or has issues, I think you have to point it out to your client, and then you can take direction from your client as to what they want to do, right? In this situation, what the facts were was no one even cared about the public report because public reports routinely are not attached to the vacant land SPUDS. That's really, the problem is we have a document that suggests that this paper should be attached there, but nobody ever does it. So no one ever thought about it. Now, of course, this buyer's saying you should have got it, and I'm like, well, dude, you did like 10 other transactions, you didn't have one, what do you care? You only care about it because this one actually had a disclosure in that you were worried about. But I think in general, it's a good question. Your obligations when a SPUDS comes in that is incomplete, at a minimum, is to point it out to your client. And then you have to take direction from your client. Okay? Your client can decide, well, am I going to go forward, or do we need to ask follow-up questions? I mean, inherently, we ask follow-up questions, and sometimes we still don't get back the answers we want. It's up to because your buyer can do what? Your buyer can cancel. Yeah. Okay. All right. So, it was $1 million that was at issue. These were all the parties. You guys have all given your different percentages. Oh, let me ask you real quick. Give me the 30 seconds. Why was the seller most responsible in your mind?
Because he should have, or she should have disclosed, and he or she is the one that had all the facts about the house, whether he read them or not, was immaterial.
Yeah, I will tell you, not to pat you on the back, because I think you were really causing some trouble over there.
Yeah,
I will tell you, that was my opinion. My opinion was the seller ultimately had the most liability here, from the standpoint of they're the only human being that actually at some point had in their presence a document that disclosed this. Everyone else had to go do something to get it. And they also signed a piece of paper that said, I read it. Okay, and you signed something that said you read it, the law presumes you read it. Now, that being said, that doesn't mean the jury agrees with that. That's just my opinion. Now, they're asking for $1 million. And just going off percentages, you don't have to give me percentages, I'm going to give you ranges. How many people in the room think that the buyer got a total of $1 million? Got everything they were asking for? How many think the buyer got at least 750,000? Meaning they would have 25% from it. Okay. How many think the buyer got at least $500,000?
Wait, real quick.
Yeah.
Is this based on
Are we talking
the
about the
total,
award or
the,
what the buyer?
What they got, what they want.
right, but when you came with the valuation, that was based on the lot, the total loss, or because the lot was what, 200 or
Well, what the,
300,000?
yeah, basically the valuation was my house after it was constructed should be worth $2 million, but because there's a waste treatment facility behind me, it's only worth $1 million, so I did $1 million. Okay, so how many people think they got at least 500,000? Raise your hand. How many people think they got at least 250? Okay, anybody think they got 0? Okay, anybody think I'm talking about a case that I didn't win? They got 0.
They got 0?
They got nothing.
Because what's next?
Well, because I didn't tell you everything. How it works is they got to prove 4 things. They got to prove duty, breach, causation, harm when they sue real estate licensing. They got to get all 4. If they miss on 1, I win. If they miss on 1, I had you jump ahead. If they miss on 1, they don't even get to do a fault allocation. They got to get all 4 first, and then the jury decides how we're going to divide up the allocation. Okay. They had the duty, because clearly we owed them a duty. I represented the buyer's agent. They had a duty. They might have even had a breach. Maybe the agent should have got the public report, or whatever. The question was, were these people harmed? What I didn't share with you are some pretty key facts. Number 1 fact is they finished construction on this house in 2007. Now for those of you that were around in 2007, what happened? And I mean around in terms of real estate. The recession. What happened to properties? Yeah, I don't care if they built a shit factory behind the house or not. This house was in deep trouble, wasn't it?
Yes.
Well, to make matters even more dire for them, what did he do for a living? You remember? How did contractors do in 2007, 2008, 2009? They didn't do very well. In fact, he couldn't make his mortgage payment. And when you can't make your mortgage payment and you want to do a short sale, you have to write a hardship letter to the bank. And you have to tell the bank why I can't make my payments. So what did he say?
I'm making money.
I'm not building a house, I'm not making any money, I can't make my payments. If you can't make his payments, what's gonna happen? You're gonna lose your house. Ends up selling the house short. Arizona's an anti-deficiency state. Anybody remember that?
Mm-hmm.
Anti-deficiency state basically says if you have the right house and you have the right loan, the only collateral for the loan is the house itself. Meaning if the bank sells it short or the bank takes it back and they don't get all their loan back, too bad, they don't get it. Right, so that means when he sold it short, because he did sell it short, he wasn't obligated on a loan. Their loan was $2 million. They sold the property short for roughly $1 million. It kind of all coincided with the valuation. Well, I'm cross-examining him. I said, well, let me understand something. You sold this property short, right? Right. And when you sold it short, because of our laws, and Wells Fargo is the lender, Wells Fargo had to eat that $1 million loss, right? And they're not coming after you, right? And they can't come after you, right? And because of the tax laws, that was forgivable debt, and you're not taxed on it, right? Right. So you have no ramifications from the short sale, right? Right. And you're asking for $1 million, yes. If you get that $1 million, are you giving it to Wells Fargo?
No.
What's his answer?
No.
What does the jury think of that? The jury thinks that's bullshit. Because who got harmed here? If you assume that the waste treatment facility did cause some decreased value, even though it's 07, it did. I mean, if there was no waste treatment facility, maybe it short sells for $1.3 million or $1.4 million or $1.5 million. And there's no question, even our experts said that hurts the value. But if that $500,000 in lost value, who lost that? Wells Fargo lost it, not this guy. So that's why they lost. That's why they got zeroed out. In many ways, we were lucky. Why were we lucky? Timing. That same fact pattern today, we don't have the same arguments. Then we have to win on duty and breach. We don't get to win on causation and harm. We won for sure on harm. Jury was out for 15 minutes. It's the shortest jury I've ever had ever. You have to give your phone to the clerk. When you give the case to a jury, you have to give your phone number, and you have to be within a half hour of the courthouse because they don't want juries waiting. So I gave my phone number to the clerk so they can call me when the jury gets back. I'm literally getting in my car and they call me and said they're back. That's what they thought of that. But a lot of that was just luck. Yes?
If that wouldn't have been, 2008 or 9, and it wasn't a short sale situation, would have potentially the buyer got something?
I think the buyer would have got something. I think that really hurt. Well, there was other things that and I won't bore
I mean,
you
not
with
the
it.
$1 million, but maybe
They would've got
$100
something.
grand.
They probably got something. If this happens nowadays, they probably get something. I think I think how it would have worked, hey, Jay. I think how it would have worked.
I gotta peek in when Dax is in the house.
That's right.
Dax Watson, the one and only.
That's me.
No, now you know.
Yeah, we know. They know now.
They know now.
They know now. If they didn't, they've known for the last 62 minutes.
The guy that keeps us out of hot water.
That's right.
here.
That's right. Rock and roll.
Alright, do your
Let's
thing.
see, Jay.
Okay.
Let me finish that thought real quick, and then you can ask a question, then I'll let you guys go, because I gotta go to the ADRE. I think how it probably would have played out if, let's say it was 2012. I think the seller would have probably got hit with the most. I think the listing agent would have got hit with the second most. Okay. I think it kind of would have depended on the jury and who they believed about that conversation between the buyer's agent and the buyer. Buyer wouldn't have got everything, because the buyer had their own due diligence. There's no question about it. And the buyer had some of their own problems. They'd have got something. But I think the seller and the listing agent would have had a problem. I mean, I could argue the listing agent would have had more responsibility than the seller pretty easily.
Yes.
You're holding yourself out as a specialist and you don't know major construction projects happening outside the gate line. I mean, if we weren't all teaming up and we decided as defendants we were kind of just going to team up and focus on the damages, I would have spent the entire trial throwing shade at the listing agent to get fault off of my guy. And I would have just said, look, we're not here. If this listing agent specialist was really a specialist, then this would have been disclosed up front and we wouldn't even be sitting here. They're the ones that pushed the snowball down the hill that turned into an avalanche because the specialist wasn't doing their job. I would have just buried it. All right, last question, then I'll let you go.
Buyer's agent, what responsibility did he or she have?
In terms of what? We won.
So they didn't have any?
No, this guy lost. We won. It was over. It's done. They got 0. We got a complete defense verdict.
So everybody won except the buyer.
Buyer got their ass kicked. That's a legal term.
I have a question.
Yes.
So you said in
Oh, I love going to trial. What's that?
You said in 2012 the buyer may receive.
I think it would be a
something.
different scenario if there wasn't the economy
So
crashing.
you get from whom?
I think it would have been, like I just said, I think the seller probably would have got hit the most, listing agent hit
So
second.
the share of the amount.
How much money do I think they would
Yeah,
have got?
yeah. Now from whom? I mean, they will share the amount?
Well, let's say they gave 40, let's say use her number, and
Yeah.
let's say they got, well, first of all, I don't think they would have got the full million.
Let us say it's $500,000. So
But let's say it's half a million,
Split
and
it,
it would have been however they did the percentages. So if they said
percent.
40% to the seller, then 40% of the,
okay.
that's how it works. So let's say, make it easy.
Mm.
If it was $1 million and a jury gave 40% to the seller, the seller's got to pay $400,000.
Gotcha.
And if the buyer themselves as the plaintiff got 40%, then they don't get that $400,000. That's how it works. Does everyone understand? All right, I got to roll because I got to go see the Department of Real Estate. But thank you guys for having me. I really appreciate it.
Thank you.
Thank you.
Sorry.